It is my great privilege to introduce our speaker today, Judge Arthur J. Gonzalez, retired on March the 1st, 2012, as the Chief Judge of the Bankruptcy Court for the Southern District of New York. His long and distinguished career began in the New York City public schools, where he taught for 13 years, after earning a degree in accounting from Fordham University, and while earning a master's degree in education from Brooklyn College. During his career as a teacher, he served as a representative for the United Federation of Teachers. That kindled an interest in law. So Judge Gonzalez went to Fordham Law School for his JD and ultimately to NYU for his LLM in tax. He worked as a staff attorney in the Office of Chief Counsel for the IRS, earning the Chief Counsel's Special Achievement Award for 3 consecutive years. He later went into private practice and then was appointed Assistant United States Trustee for the Southern District of New York. 2 years later, he became the U.S. Trustee for Region 2, that is the Second Circuit, and 2 years after that, a bankruptcy judge. He currently serves as Senior Fellow at NYU Law School, where he taught as an adjunct previously for several years. He now has a new home for his collection of Hess toy trucks and the photographs of his beloved Brooklyn Dodgers. And those of you planning to join the New York Bar will be particularly interested to know that upon his retirement from the bench, Judge Gonzalez was appointed to the Character and Fitness Committee for the New York Supreme Court Appellate Division, First Department. While on the bench, Judge Gonzalez handled numerous large corporate bankruptcy cases, including 3 of the largest ever filed: Enron, WorldCom, and Chrysler. Enron, filed in 2001, was the first of them. It was so complex that Judge Gonzalez did not receive another new case assignment for over 6 months. But then, only 2 months after going back into the rotation, he was assigned to WorldCom, then the largest case ever filed. So not only did Judge Gonzalez have 2 of the biggest cases to date, he handled them simultaneously, with the assistance of, at one point, 8 law clerks. Judge Gonzalez did not get a new case this time for 6 years. As you can tell, the word tireless does not begin to capture Judge Gonzalez. Both of his graduate degrees, his master's and his law degree, were earned at night after a full day of dealing with the challenges of public school classrooms. And if that is not enough to prove my point, then my case is made by the fact that he has run 30 of the last 32 New York City marathons. He participates in triathlons, and he has done the annual sprint of 86 flights in the Empire State Building 6 times so far. He says his joints are fortunately doing fine. I would add, so is his mind. He's a New Yorker through and through, and we're glad we could pry him out of the city to spend an all too brief time with us here in Virginia. Ladies and gentlemen, the Honorable Arthur J. Gonzalez.
Thank you, Professor. It is certainly an honor to be here at this prestigious law school within this historic university. It is an enormous pleasure and honor and humbling to be asked to give this lecture today. And it also is a wonderful experience to get to see Tammy Brandt again. Tammy was one of those law clerks over the years who made my life a lot easier every single day. And Tammy was one of the authors of the venue motion in Enron, one of the most controversial decisions there has been dealing with venue. In any event, today's lecture, the U.S. auto industry, was it too big to fail politically, economically, or both? And how a part of that bailout saga played out in the Chrysler bankruptcy case. I'm more than welcome to take questions. As soon as I finish, hopefully we'll have time before you have to leave for your next class, and I will respond to any of your questions. In September 9, 2008 New York Times article entitled, "Who Else Can Pile On for Federal Rescue?" published while the business world was wondering whether Lehman would file for bankruptcy protection. The question was posed, is the definition of too big to fail getting broader, or are some industries simply more important than others? The article further noted that following the rescue of Bear Stearns, the mortgage finance giants Fannie Mae and Freddie Mac were seized by the government. At the same time, the U.S. auto industry was seeking government assistance in the form of loans to finance the development of new energy-efficient cars. The article as well offered some views on how to define too big to fail. It referenced comments from Robert Ruman, the former Clinton administration Secretary of Treasury and later senior advisor at Citicorp, who stated that Bear Stearns was not too big to fail, but too interconnected to fail, and that Fannie and Freddie were both too big as well as too interconnected. The article also mentioned the definition of too big to fail by Richard Breeden, the former SEC chairman during the George H.W. Bush administration from 1988 to 1992. According to the article, Mr. Breeden is often regarded as the architect of the savings and loans bailout structure. During that time of his tenure, Drexel Berman had failed and filed for bankruptcy protection. In the article, Breeden is quoted as stating that he, as the SEC chairman, did not step in to prevent the collapse because he felt that the collapse of Drexel Burnham could be absorbed by the marketplace. Breeden defined too big to fail as when the failure of a particular company will cause a ripple effect and otherwise healthy institutions will be forced into insolvency, affecting the overall economy. He further stated that shoring up Fannie and Freddie wasn't even a close call. Failing to do so would have caused a wave of problems to institutions around the world, and that it was a wave big enough to drown a lot of people. Regarding the auto industry, he said, on the other hand, helping the American automakers might have strong political support, but does not meet the economic test. He continued, if you are trying to win the electoral vote of Michigan, you promise who knows what, but in terms of risk to the economy, it's not an immediate threat. The article does not mention Lehman, but it would seem that every element of too big to fail definition referenced in it squarely fits within the Lehman situation. Lehman, a far larger institution with presumably greater market impact, would appear to have warranted government intervention, at least on a par with that of Bear Stearns. Having read that article, I was convinced that Lehman would be bailed out by some form of government intervention. The day before Lehman's filing, I was at a wedding reception where I spoke with someone who identified himself as a Washington lobbyist. When he found out that I was a bankruptcy judge, he asked me if I thought Lehman would file for bankruptcy. I told him that I expected that Lehman would receive some form of bailout since it was larger than Bear Stearns, and that I would expect the rationale to be that Lehman's collapse would cause the ripple effect referenced in the September 9th article. The lobbyist responded that he believed that the Federal Reserve Bank and the Department of Treasury were of the view that they were in a better position to react to a Lehman filing than they were when they confronted the Bear Stearns crisis. In other words, they believed they had the necessary tools to prevent the systemic failure of the financial system that was feared if Bear Stearns, Fannie, or Freddie were to fail. Obviously, my prediction was wrong. Lehman filed on September 15, 2008. It is, however, equally clear that letting Lehman fail had the national and global consequences far more reaching and devastating than anticipated. The measures in place did not enable the market to absorb its collapse. The 2009 auto industry bailout must be viewed in the aftermath of Lehman and the consequences that followed. I do not mean to infer that had Lehman been bailed out, that we would not have had eventually suffered an economic crisis. I do, however, believe that had the impact of Lehman's collapse had been better understood, the consequences would have been managed better. Whether those in power should have had a better understanding of the consequences that would follow is a question that I have no basis upon which to form an opinion. However, the lesson of Lehman's failure for policymakers reinforced the concept of too big to fail, that large, economically important companies must be bailed out because the potential consequences of their failure are dire and unpredictable. After Lehman, there was a thumb on the scale in favoring of a bailout of institutions that might systemically be important to our economy. When turning to the issue of industry bailout, an entity's political power is a factor in the political calculus of bailouts. Certainly, we have seen numerous industries diminish and leave our shores without government intervention. Steel, textiles, furniture, etc. have all dramatically diminished without government intervention. Presumably, all of these industries and their interested parties had political power. Was the difference between bailout or not simply the economic conditions of the time, or was simply a matter of greater political power of the UAW and the auto industry? Was it that the concentration of such political power of the other industries simply not in battleground or swing states? Was the political fallout from a bailout for those industries too big a price to pay? Or was it the consequences of a perfect storm of economic and political circumstances that convinced both administrations that a bailout was the only option? As for relative union political power, I am not sure whether in its heyday the United Steelworkers and the UAW were relatively equal in political power. But I do believe that whatever political power the unions and others dependent on those industries mentioned above had within the political structure of their relative states, that power would at least be at its height when a particular state or states would be deemed pivotal from an electoral standpoint by the parties. Just as an industry's economic importance can be greater at a time of general economic distress, the political power of an industry can wax and wane along with the election cycle. We will never know that answer, but in 2009, there was in many respects this perfect storm of economic and political factors that made the political argument for a bailout most compelling. In 2009, there were at least two political arguments that pointed to bailout. One was present pre-Lehman, the swing state issue, and how that would have influenced the landscape regarding bailout. The consequences of failing to act would have to have been weighed against the consequences of acting, and how such government intervention would be received by the country's voters. But post-Lehman, the issue of bailout seemed to me to go far beyond the swing states and focused on the risk that the presiding administration would be responsible for an either greater economic mess than we have already were experiencing. It is my view that the latter concern ultimately was a driving force for each administration as they struggled to get the economy back on track. By their actions, we know that post-Lehman, neither the Bush administration nor the incoming Obama administration believed the economy could absorb an auto industry failure. Although we cannot know with any certainty how each administration would have reacted had the economy not been as what we find in the post-Lehman era of late 2008, is a very fragile U.S. and world economy. Economies that may not be able to withstand any more systemic shocks. The foreboding economic environment was such that many of those who may have seen the failed the auto industry as a natural evolution of the demise of U.S. manufacturing industries came to realize that what may have been absorbed pre-Lehman may have dire consequences in the post-Lehman era. Over the years, the United States had great decline in manufacturing sector. As mentioned, we have seen steel, textile industry leave our shores for better cost structures abroad. So why was the auto industry saved? Again, was it done because of its perceived impact on our economy, political process, or both? Further, assuming that the auto industry should be saved, was it necessary to save Chrysler and GM, or could the industry have absorbed the failure of Chrysler alone? I can only speculate as to what may have been in the minds of the decision makers regarding whether to save the auto industry, and then if so, to what extent. The political answer to the auto industry question has a number of different aspects. The auto industry is symbolic of American business. Even though the industry's image is not what it once was, it is not likely that the leadership of either major political party in the United States wanted to be responsible for letting it fail. Also, based upon the political landscape, a number of the states that would be most impacted by an auto industry collapse are considered swing states or battleground states. Each party believed that they were able to secure such states with their respective electoral votes. Since we do not, as you know, how we elect our president by electoral votes, this was crucial in the analysis of what to do politically. Further, on the economic side, after Lehman's collapse, even if one could argue that our economy could withstand the loss of the auto industry before Lehman, as I said before, it's difficult to believe that the fragile nature of the American economy post-Lehman could withstand such a failure. As referenced previously, once a determination was made to save the auto industry, the question arose as to whether to save Chrysler and GM or just GM. As for Ford, it was able to secure financing prior to the tightening of the credit markets, so it was not as vulnerable as the other two major automakers, Chrysler and GM. Under that formula, one would argue that the auto industry needs to be saved and GM, as the world's largest vehicle producer, would need to be bailed out. But again, what about Chrysler? Chrysler, as the smallest and weakest of the three, presented the biggest question as to whether it should be saved. From both a political and economic standpoint, if one were just to focus on Chrysler itself and the size of its workforce, one could determine that its failure in 2009 could be absorbed. However, it has been argued that one of the considerations that likely saved Chrysler was the fact that our auto parts manufacturers supplied to all three companies. A loss of Chrysler's business, even if it was the smallest of the manufacturers, would likely put enormous pressure on the auto parts supplier, and if they failed, they could bring down all three auto companies due to the domino effect of the auto industry's part supply chain. Because the manufacturers did not keep large inventories of parts, operating in just-in-time inventory management systems, the big three automakers depended upon the steady flow of parts from their suppliers. A failure of a supplier could stop production in a relatively short period of time. And as most parts were made to order and were often sourced from a single supplier, replacing a supplier was a difficult and time-consuming process. Thus, although each automaker was a distinct entity, their potential failure was inextricably intertwined. In this way, the interconnectedness of the auto industry supply chain presented a too-big-to-fail problem that could produce a systemic failure even if the smallest company in the industry failed. This is similar to the situation in the financial markets, where the failure of Lehman Brothers, one of the smaller investment banks, caused the commercial paper market to freeze. Excuse me. The next section of my presentation turns to Chrysler's case and how it proceeded in the bankruptcy process. But before I discuss Chrysler, I'd like to comment on too big to fail in the context of two other cases I presided over that received a great deal of attention. In December 2001, immediately before Enron failed, a request was made to the Secretary of Treasury under the Bush administration to intervene to prevent the failure. Actually, that request was made by Robert Rubin, then with Citicorp. However, this request was rejected. And while the fall of Enron, the seventh largest U.S. company at the time, impacted the energy trading market, the general U.S. economy was resilient at the time, and Enron's failure was absorbed by the market. Soon thereafter, many companies in the telecommunication industry failed, including WorldCom, which was at the time the fourth largest U.S. company, at $106 billion. Enron was at $64 billion. Like the case of Enron, WorldCom filed for bankruptcy, and the broader market absorbed its failure. I mention this observation for one reason. From an economic standpoint, too big to fail must be viewed within the context of the overall economy at the time. To a great extent, political intervention in an industry, whether an industry bailed out or not, is significantly impacted by factors outside the industry itself. Long before the 2008 financial crisis, the auto industry was steadily losing market share. This was due in part to the industry's failure to produce fuel-efficient vehicles, as well as its soaring labor costs and associated legacy costs. As for Chrysler, as again it was the smallest of the three major U.S. auto manufacturers, it had performed well with its minivan line and its Jeep product, and although Chrysler's Jeep brand continued to be successful through 2008, Chrysler no longer dominated the minivan market, and it did not have any product that could compete in a fuel efficiency line. As Chrysler continued to suffer increasing losses, the company and its major lenders sought alternatives as early as 2007 for a possible sale or merger of its business. It is widely known that as Chrysler continued to lose market share, its lenders sought such a solution. Generally, as part of that effort, there were discussions with the United Auto Workers Union regarding contract terms and conditions. By the fall of 2008, as the slowdown in the global economy took its toll on an already struggling U.S. and world auto industry, both GM and Chrysler were running out of cash. Traditional sources of funding were not available. These two companies had a very different debt and equity structures. GM was a publicly held company and had very little secured debt. Chrysler, on the other hand, was a privately held company, had virtually all of its assets encumbered. But each company shared a common problem. There was no ability to access the capital markets and suffered from an unsustainable cost structure. Because of these and other factors, in the midst of the financial crisis, Chrysler's efforts to seek a merger failed. GM as well continued to seek solutions for its problems with no success. As a result of this deteriorating situation, both Chrysler and GM were forced to turn to the government as the lender of last resort. By the end of 2008, after contentious congressional hearings, several unsuccessful legislative initiatives, and in response to the request from Chrysler and GM for loans of over $25 billion, then Treasury Secretary Paulson of the Bush administration announced that Chrysler and GM initially would receive $17.4 billion in funds from the Troubled Asset Relief Program. Thereafter, as auto sales continued to decline, it became apparent that additional funding was necessary, since funding would need to exceed the level that was already anticipated. As such, Chrysler and GM sought additional TARP funding. Regarding the TARP loans, the terms of the loans agreement were identical for both Chrysler and GM. Each agreement required submission of a revised business plan by February 17, 2009, establishing each company's viability and ability to repay the loans. Following the February submission of Chrysler's plan, and after review by the task force, President Obama stated in a March 31st speech that a successful turnaround would require unions and workers who have already made hard, extraordinary, painful concessions to do more. Creditors to recognize they can't hold out for the prospect of endless government bailouts. And efforts from a whole host of other stakeholders, including dealers and suppliers. At the same time, President Obama announced that without an agreement with Fiat or another appropriate partner and other stakeholders, the U.S. government would refuse additional funding in 30 days to Chrysler. Fiat had emerged as a possible merger partner prior to the President's March 31st statement. Meanwhile, GM was also under a great deal of pressure to work with its essential constituents to reach an accord on labor and other costs. The next section of my presentation will focus on Chrysler's case, since I am more familiar with the facts and circumstances that led to its filing and subsequent events. Further, My comments all today have stemmed from my observations during this period as a bankruptcy judge. As a threat of ultimate downward spiral into the liquidation loomed, Chrysler and its interested parties, including Fiat, began round-the-clock negotiations to reach a deal. Quite simply, all the pieces needed to come together, otherwise Chrysler would face the ultimatum presented by the Obama administration. No additional funding would have resulted in an immediate liquidation that would not capture any going concern value for anyone. In advance of Chrysler's filing for relief under the Bankruptcy Code, preliminary negotiations involving Chrysler, Fiat, UAW, note holders laid the groundwork for what ultimately proved to be a successful restructuring and sale of Chrysler. While establishing the terms of the sale to Fiat, negotiations with lenders and the UAW were simultaneously underway. A fully consensual resolution was in sight for all the relevant creditor constituents, except for the holders of the first lien credit facility of $6.9 billion held against Chrysler's assets. The last pre-bankruptcy proposal to Chrysler's first priority secured note holders involved eliminating their $6.9 billion in secured debt in exchange for $2.25 billion in cash, but only if 100% acceptance could be achieved. Absent that acceptance, the offer was $2 billion under a sale proposal in bankruptcy. Although Chrysler's largest note holders agreed to the debt exchange at the $2.25 billion level, smaller note holders demanded a higher offer, resulting in a rejection of the offer and the reduction in the proposal to $2 billion in cash. Absent unanimous consent from the note holders, Chrysler was forced to proceed with its bankruptcy filing. As an aside, it's not clear as to whether, even if unanimous consent of its lenders had been received, Chrysler would still have had to file for relief under the Bankruptcy Code to accomplish some of the cost-cutting measures it needed to achieve. However, had a consensual agreement been achieved, the reorganization of Chrysler would have been far less contentious than it actually was. Even though Chrysler was left with no choice but to file for bankruptcy, the pre-bankruptcy negotiations proved to be an essential framework for the successful restructuring and sale of Chrysler to Fiat that followed. The Fiat and UAW agreements and the willingness of the majority of note holders to accept the $2 billion cash offer proved vital to securing the U.S. government's funding for a quick and efficient restructuring. Additional significant pre-bankruptcy issues confronted the Auto Task Force and Chrysler and the other major parties. These issues included questions concerning venue, questions related to Chrysler's labor costs, dealerships, technology, and the company's relationship with the UAW and its note holders. From the court system perspective, in the fall of 2008, it was quite clear that Chrysler or GM or both would likely seek some form of relief in bankruptcy. However, it was simply unclear in what venue the cases would file. The administrative arm of the U.S. court system began to prepare the clerk's offices of the likely venue possible filings. Venue can be a significant issue in a bankruptcy filing. Since there were no Supreme Court precedents on what were perceived to be the key issues to effectuate the sale of Chrysler and GM, circuit court consideration became a primary driver of venue. Under the venue statutes, there were three likely jurisdictions in which companies could file. Detroit, Michigan, representing the principal place of business of the parent company and many of its subsidiaries, as well as the location of the parent's principal's assets. Wilmington, Delaware, representing the state of incorporation of the parent company and many of its subsidiaries. And New York, New York. Under the venue rules governing affiliate case filing, if the first filed debtor has venue in a particular jurisdiction, affiliate debtors can file there for venue purpose. At least one of the affiliates of each of the auto concerns auto companies had an affiliate that would qualify for venue purposes in New York. In fact, Chrysler had a real estate entity in the subsidiary in New York, and actually GM's venue link in New York was a, I lost track of the name of the car manufacturer. It will come to me later, but anyway, there was one car manufactured by GM that was owned by GM, and they owned the dealerships. And as a result, there was a dealership in the Bronx of New York that was the first filed case in the GM case. The efforts of the administrative office of our federal court system included setting up computer systems that would be equipped to deal with the presumed massive amount of activity that was expected from a filing with the magnitude and used public interest of the auto industry case, of an auto industry case. As for the companies themselves, in 2008, each retained law firms and other professionals to provide advice regarding a possible bankruptcy filing. The Auto Task Force continued to develop a strategy for a bankruptcy filing. The critical questions were, what was to be achieved and how would it best be achieved? The task force identified a number of central issues that needed to be addressed through a bankruptcy filing. The cost of labor was a significant one. In addition, a number of dealership costs concerned. Further, Chrysler specifically needed to obtain small car technology in order to respond to the market demand for more fuel-efficient cars. To achieve a reduction in labor force, an understanding was reached with the UAW that in exchange for the protection of the UAW retirees' health and welfare system, the employees would agree to wage reductions and beneficial work rule changes. Chrysler agreed to reduce its dealership network, and the majority, as I said before, the note holders agreed to accept a $2 billion offer. Since Chrysler had operations in Canada, Canada was also a participant in the process and the various financing of the purchase and the operation of Chrysler during the bankruptcy. Fiat was the proposed purchaser along with the government, subject to higher and better bids, if any, during the sales process. Fiat's participation brought Chrysler the small car technology it wanted, and Fiat in exchange received access to the U.S. market for its models. The note holders certainly wanted to receive more than what the government was willing to offer, but they knew that a complete liquidation of Chrysler would have resulted in less of a recovery, if any. However, the note holders needed the government's funding in a bankruptcy because they did not want to fund the bankruptcy themselves, even one that would contemplate a sale within a relatively short period of time. This was because the risks were too great that the process could get delayed, and the funding for a bankruptcy might never be recovered through the sale. Further, the risk that a loss in consumer confidence leading to the loss of sales and negatively impacting the going concern value of the company would occur increased the longer the reorganization process would take to complete. It was feared that the greater loss of going concern value would follow. There were also a number of other strategic financial considerations that dictated the timeline of Chrysler's bankruptcy. A company that enters bankruptcy process must be able to fund this operation in order to sustain itself during the pendency of the case, and with the goal of preserving going concern value of the entity. With that said, how does an entity sustain itself during bankruptcy? One method would be from the current cash flow of its business operation. Another option is for the company to preemptively accumulate a great amount of cash before the filing to sustain itself during the bankruptcy case. Still another would be to obtain financing, which under our system would have a priority over pre-filing unsecured claims. However, if the assets of the debtors are secured by other financing, the new financing would not receive a priority position over existing financing unless the court were to order otherwise. Such an order would be a priming order. Consensual priming is granted at times, but non-consensual priming is very seldom sought, and if sought, often not granted. A priming fight is a very disruptive, especially at the beginning of the case, to the operations of a business and can have a devastating impact on the business ability to sustain consumer confidence. Therefore, absent an ability to fund the case through operations, which Chrysler did not have, The debtor must look to a new lending arrangement to finance its operations. As a result, the length of time a company is able to continue in operation in a Chapter 11 is greatly influenced by the post-petition lender under the post-filing lending agreements. Where then did that leave Chrysler? Virtually all of its assets were subject to the lien of the noteholder lending facility. It was widely accepted that those assets were worth far less than the amount due to the noteholders. Following the noteholders in the priority scheme of secured creditors, Service had a lien that followed the noteholders, and thereafter the government had a lien from its $4 billion that was advanced in January of 2009. A common source of lending in this situation would be a loan from the first lien holders, but they weren't about to lend any more money. As stated earlier, the note holders were not willing to advance the funds. The only lender that surfaced was the U.S. government. The government had previously lent TARP money to Chrysler under the Bush administration in early 2009. It became self-evident that neither President Bush nor President Obama wanted history to say that they did not act to save the auto industry. The Auto Task Force then proceeded to analyze the needs of the auto industry, and especially the needs of Chrysler. As we know, that the answer to the question from the auto industry was that Chrysler would be saved. Having made that determination that Chrysler would not be left to fail without an attempt at its savings through the bankruptcy process, the Auto Task Force needed to make a number of decisions. And again, we return to the venue issue. From one standpoint, it's necessary to know what type of relief will be sought in order to decide among the various venues. The relief to be sought in an auto case was a quick sale of substantially all the assets outside of plan or reorganization. That type of relief has been granted in bankruptcy cases before, and the leading case setting forth the applicable standard for such relief was in the Court of Appeals for the Second Circuit. The Bankruptcy Court in New York, being in the Second Circuit, is bound by the precedent set forth in the circuit dealing with the sale of substantially all the assets outside of a plan. It was viewed that the law on Section 363, sale of substantially all the assets, was not fully developed in the other circuits in which venue could have lied. There are certainly other factors that were taken into consideration when deciding the choice of venue, including the experience of the court, its judges to handle cases of this size, significant public interest in the auto industry cases, the convenience of the court to the central parties, etc. How many of these and other factors were considered by the debtors and the U.S. government is something to which I have no first-hand knowledge. Simply put, the determination was made to file in the Southern District of New York. On the morning of April 30th, 2009, Chrysler filed its petition in the Bankruptcy Court for the Southern District of New York, and I was assigned the case through the random selection process. What followed was a court process journey that culminated in the sale of Chrysler, which became the outline for the sale of GM. The Chrysler sale was completed within 42 days of the filing on April 30th, 2009, with the closing that took place on July 10th, 2009. It included 2 hearings in the district court, a direct appeal to the Second Circuit, and a Supreme Court one-day stay extension of the sale closing. I will now try to summarize the course of key events that followed in the subsequent 42 days, culminating with the sale of Chrysler as contemplated by the Auto Task Force. On April 30th, the day of Chrysler's filing for relief was a Thursday, and the parties did not seek to come before the court until the following Wednesday, May 5th. Often debtors need to go before the court on the first or second day of a case in order to seek some immediate relief. Relief is sought in most large cases on the first or second day. These hearings generally address issues related to financing as to enable the debtor to continue its operation. Here, an agreement was reached with the note holders on the use of funds that were in the bank accounts of the debtors for which the note holders had a security interest. Therefore, there was no need to be before the court prior to May 5th. At that hearing, the most important issue raised before the court was the scheduling of the proposed sale of Chrysler's assets. Immediately before the filing, Chrysler had closed all its plans and did not plan to reopen them unless a sale was consummated. During this time, it was estimated that Chrysler was losing $100 million a day in going concern value. Even though it had shut down operations, Chrysler was still spending a great deal of cash maintaining its plants and equipment, as well as paying its employees. There were three groups that expressed concern about the process. One group consisted of the dealers who were worried about whether Chrysler intended to reject dealerships contracts as part of the sale process. Another group consisted of those who had tort liability claims against Chrysler and who were concerned that the purchaser would not be liable for such claims, thereby leaving only the debtors liable for the claims. The third group was a minority of note holders who argued that the process should be delayed to allow for further negotiations with the government, seemingly recognizing that a sale was necessary but objecting to the sale because the government-funded price was not high enough in their view. After hearing the parties, including the Creditors Committee Council, a schedule was set for the sale that was about a week longer than what was requested by the debtors. The U.S. government, which was providing the financing to the debtor, agreed to the delay in the sale process. This point is key to understanding the dynamics of the influence that lenders have in our system when a debtor's assets are fully encumbered by secured lenders. If a debtor does not have sufficient cash to continue in this Chapter 11 on its own, it then has to depend on the provision of cash by post-petition lenders, which can lend under specific periods of time, for specific periods of time, and the court is without any power to order them to lend for a further period. In the auto industry bankruptcy cases, the government functioned as the lender of last resort, and in each case, the government refused to extend its lending for a period necessary for a planned process to take place. It was argued that the process could be dragged out for an extended period of time, and that would have a dramatic negative impact on the survival of each entity in the auto industry itself. One cannot lose sight of the government's purpose under the circumstances. It was to save an industry and not just preserve the Chrysler entity or the GM entity. A central theme articulated by many of the objectors throughout the sale process was that if the court denied the relief, that being the expedited sale process, the government, which has a limitless supply of funds, would put more money into the process. Whether that was accurate or not, it seemed to me to place the court in a position of advancing one side's position to the detriment of the other was not proper. And in my view, as long as the integrity of the process was maintained, it was not the court's role to deny relief sought, because I thought the government would increase the price if I simply denied the relief at that moment. It was a process, in my view, in which the government bore the burdens and benefits of any funder of a sale process. It should be a market-driven process, and if the market did not provide greater consideration than was being offered, it was not the role of the court to alter the process. In the context of Chrysler's bankruptcy, the government acted in its capacity as a private lender, regardless of its political motivations, and was treated as a private lender under the Bankruptcy Code. Turning back to the time frame, the sale hearing was set for May 26th. It continued until concluded. Until May 26th was a Wednesday, it concluded at approximately 8 o'clock Friday night, or 10 o'clock Friday night. During the period before the sale, the parties engaged in extensive discovery in preparation for the sale. This discovery occurred in 3 different cities simultaneously. During this period, one of the note holders, the Indiana pensioners, sought relief from the district court, the court level above, obviously, the bankruptcy court, to stay the sale process. That request was denied, and the preparation for the sale process continued unabated. While the parties prepared for the hearing, the court and its staff prepared to write an opinion. The court spent a considerable amount of time researching the standard for a sale as proposed, and as the hearing approached, the tension grew amongst the parties. On Wednesday, May 26, as I said, the sale hearing began. and concluded on that Friday. Over those 3 days, it consumed 30 hours of hearing time. The court and its staff worked throughout the weekend, and on Sunday, May 31st at 11 p.m., the court issued its opinion approving the sale. In the opinion, the court directed the debtors to submit an order to the court regarding the approval of the sale. The court further set June 5th as the earliest date for the time the sale to close. On Monday morning, June 1st, the morning after I issued the opinion approving the sale, GM filed this petition in the bankruptcy court in the Southern District of New York. Later that morning, in the Chrysler proceeding, the counsel for the Indiana pensioners sought a stay of the closing beyond the June 5th date. The district court stated that it thought the request for a stay was premature since I hadn't issued the order yet regarding the opinion. The debtors argued that an appeal in the case met the standard for an immediate review by the Court of Appeals, and therefore sought relief before the bankruptcy court to certify the case to the Court of Appeals on a direct appeal. Later that day, the bankruptcy court certified the matter to the Court of Appeals. On Tuesday, the Court of Appeals set an expedited hearing time of Friday 2 p.m. It's Friday, June 5th at 2 p.m. for argument on the appeal. The Court of Appeals granted the request for the direct appeal, extended the stay so that the court could have that Friday hearing. On Friday, there was a 2-hour hearing before the circuit, and after a brief recess, the circuit ruled that for substantially the same reasons set forth in my opinion, they affirmed and extended the stay of the closing until Monday, June 8th at 4 p.m. This was done to afford the parties an opportunity to seek relief before the United States Supreme Court. Relief was subsequently sought in the Supreme Court in the form of a request to stay the sale until it was able to provide a complete review of the entire sale process by the Supreme Court. At 4 p.m. on Monday, June 8th, the Supreme Court continued the stay put in place by the circuit until it ruled on a further staying of the sale. On Tuesday, June 9th, 2009, approximately, I believe, 8 o'clock at night, the Supreme Court lifted the stay that allowed the closing to go forward, and in fact it went forward and closed, as I said earlier, on June 10th, 2009. The circuit issued an opinion explaining its basis for affirming the June 5th, 2009 sale order in an opinion issued on August 2009. The circuit's August 2009 opinion was subsequently vacated by the Supreme Court on procedural grounds in December of 2009. As a result of that vacature, there is no appellate opinion regarding the May 31st, 2009 opinion of mine. The appellate law on the sale of substantially all the assets outside of a plan of reorganization remains the same in the Second Circuit. In the 42 days the sale of Chrysler closed, there were 2 trips, as I said, to the district court within that time, a circuit court full review, and a Supreme Court ruling on a stay. I know of no other bankruptcy matter that went through these stages of the appellate process as quickly. It is certainly true that each court recognized the importance of the issues to the parties, but more fundamentally to the public interest. Recognizing the importance of the case and being able to meet the standards of the case from a judicial efficiency perspective required an enormous effort at all court levels. On June 1st, as I said earlier, GM had filed its bankruptcy petition, and by early July, its sale was completed as well. Within 75 days, both auto companies had been sold to government finance purchasers. 2 new companies then emerged from the bankruptcy process, better positioned to compete in the auto industry marketplace than their predecessors. This overall result, where businesses were reorganized successfully and going concern value was captured, demonstrated the flexibility and importance of the bankruptcy code in responding to economic distress at both the micro and macroeconomic levels. The auto industry cases have engendered a great deal of debate regarding the propriety of the use of the sale process outside of a plan. But there are, I believe, 2 major aspects of that debate that too often get conflated. One is the political discussion over the role of government in a free market society when confronted with a major economic crisis such as the one the country faced in 2008 and 2009. The other is the bankruptcy process and the sale of a business outside of a planned process, and whether it should be authorized and under what circumstances. I can only hope that the debate over the auto industry bailout continues, both in the political and legal issues, and hopefully, most hopefully, they are addressed separately and not combined. It has been an honor to be before you, and thank you for your attention. And if anyone has any questions, please feel free to ask them. Not 100% sure I can answer them, but go ahead.